Some quick housekeeping items before we get started. We're happy to be starting some hybrid sessions. Virtual participants will be muted in the meeting, and we encourage all to please enter any questions you have into the chat box. The speaker will answer your question during the Q&A toward the end. This session is being recorded and will be available on our YouTube channel, West San Gabriel Valley Realtors. Our awesome co-host today is Vincent Howe, who will introduce our topic and guest speaker. Vincent, take it away. Vincent, you're on mute.
Sorry. Thank you, Jeff. Yeah, this is Vincent Howe from VAC Realty. Welcome today. Today's topic is 2022 legal update. And we're honored to have Mr. Hutchinson to speak about the legal update for us again. I have been listening to Mr. Hutchinson's legal updates for many years. I believe most of us already know Mr. Hutchinson, but let me still introduce him. Hutchinson, the Assistant General Counsel of the California Association of Realtors. Has been with the C.A.R. since 1985 and manages C.A.R.'s member legal service program in Los Angeles. Advises realtors through the hotline on all aspects of real estate law, and he trains and supervises other hotline attorneys. Received his bachelor's degree in history from Princeton University and his Juris Doctorate from the University of Pennsylvania. He has written for California Real Estate Magazine, co-authored C.A.R. continuing education courses, and is a master instructor for the education division of C.A.R. with certification from the California Department of Real Estate. He also regularly speaks to the association's boards of realtors, affiliated trade associations, city and the county bar association, and the major real estate firms. Without further ado, Mr. Hutchinson, the floor is yours.
All right. Thank you, everybody. Thank you, Vincent. And Jeff, good to see you guys. One of these days, I'm going to see you guys in person. I think we're getting near to that point. Probably just as well today. I have a cold. It's probably just as well I'm on Zoom today. Don't worry, I don't have COVID. I have a cold. But so virtual is good today. And I know this is recorded, so you can go back. I'm going to give you a lot of information, but you can always go back and listen to it again if you don't get it. This is a legal update. It's a very convenient time to do this because in 2 weeks, there's going to be some new forms coming out. Remember, C.A.R. does new forms twice a year, June and December. And you remember what happened last December, there was a new purchase contract. So that's what sort of been the big thing you've been dealing with for the last 6 months. And then in a couple of weeks, there'll be some more new forms. But I'm not just going to talk about the new forms. I'm also going to talk about a lot of laws also, okay? By the way, I'm going to talk about forms, but if you want to see another webinar that they're actually going to show you the forms on the screen on June 14th, a week from today at 1:30, there's going to be a free webinar on the C.A.R. website, and that's going to be recorded also to talk about the new forms. Okay. All right. I might as well, since here we are in June, there's some laws that are going to take effect on July 1st, which you should all be aware of. So let me start with talking about that. Okay. As Vincent said, if you have any questions, or I forget which one said it, you can just put them in the chat, and I may take them as during the class, and I'll also have time at the end to take them, okay? But feel free to put your questions in chat right now if they have. Okay, so first let's talk about new laws that you need to know about for this year and some of the forms related to that. First of all, did you know that if you're a landlord in California, there's this new mandatory mold information booklet you're supposed to give to your tenants? It's called information on dampness and mold for California renters. It's only for new tenants. If you had a tenant last year and there's still a tenant this year, you don't have to give it to them. But if you had a brand new residential tenant this year, make sure you give them the booklet called Information on Dampness and Mold for California Renters. Where do I find this booklet? It's on zip forms in the library called Electronic Publications, EPUBs. Just email it to your tenant. You don't have to give them a hard copy, but make sure your tenant receives, any new 2022 tenant receives that booklet. That was January 1st. Now let's talk about July 1st, new laws you need to know about. For one thing, there's this new disclosure form coming out July 1st called the Fair Appraisal Act Addendum. But don't worry about it. You're not going to have to think about it because it's going to be pre-attached to the purchase contract. So as long as you use the C.A.R. purchase contract, you're going to be satisfying your obligation to give the to give the buyer this new form. It's called the FAAA, Fair Appraisal Act Addendum. It's going to be automatically attached to the purchase contract. In paragraph 8B, there's going to be a checkbox. It's going to be pre-checked. It's going to say Fair Appraisal Act Addendum. The only thing you got to do as a realtor is make sure your clients sign it. So it's going to be attached to the purchase contract. Make sure they sign it. Remember, right now, there are 6 forms attached to the purchase contract. The 2 agency forms, the wire fraud advisory, the fair housing advisory, the buyer inspection advisory, and the privacy notice. Well, in a couple of weeks, there's going to be one more form attached to the purchase contract, which is Fair Appraisal Act Addendum. Now, unlike the forms I just mentioned that are already attached, they're not really required. Well, the agency law forms are, but hopefully you've already gotten your clients to sign them before you even got to the contract. But this new one, unlike those advisories, is an addendum which must be signed by buyer and seller. Okay, so make sure they sign it. What is this form going to say? All this form does is it tells your clients, if you just got an appraisal and you think the appraisal was biased, you think the appraiser was biased, and the appraisal basically was artificially low because of discrimination, this form is going to tell your clients where to file a complaint. In other words, they can't get out of the contract, they can't reject the appraisal. It just tells them appraisals are supposed to be not discriminatory. If you think you got a biased discrimination appraisal, here's where to file a complaint. That's all you have to do. Okay, all right. And that form is going to be happening automatically. Here's another new thing. Have you ever heard of a deed restriction or a CC&R that says something discriminatory? For example, sometimes on the property that have been around a long time, there's this restriction attached to the property that says something like, this property can only be sold to Caucasians, or something like that. Now, you know that's not legal. So who cares? Well, the point is, some people are offended. Says, I don't like the fact that that restriction is attached to my property. I don't like the fact that that's in the CC&Rs. I don't like that. That should, I want that removed from the public record so it's not attached to my property anymore. Okay, so on July 1st, there's a law that says if you own a property and you have one of these restrictions, you can go to the county recorder's office, fill out a simple form, there's no fee, and the recorder's office has to eliminate that deed restriction for no charge within 3 months. How does that affect realtors? What if you have a listing or a sale and you happen to be aware that the property you have listed or are selling has one of these discriminatory restrictive covenants? You have to tell your client, hey client, did you know that there's this new procedure where you can get this removed for free? Do we have a form for this? Of course we have a form for this. It's called disclosure to buyer or owner of discriminatory covenants. Is it on zip form? Yes, but it's not on the forms library. It's in the library called sample legal letters. So you would look that up. You would find it's called disclosure to buyer or owner of discriminatory covenant, and you would give it to your buyer or seller. Now, you only have to do this, though, if you know that there's a restrictive covenant. And chances are you're not going to know anyway, because the realtor is not required to check the deed. You're not required to read the CC&Rs. So you probably won't even know it. But if you happen to know it, give your clients this sample legal letter that's on zip forms, and you're okay. All right. Okay. That's July 1st. Let me talk about some other things that affect realtors. Starting next year, when you renew your real estate license, you're going to have to take a new class, a new 1-hour class on fair housing and implicit bias. There's going to be an extra hour of continuing education. If you renew your license this year, you don't have to do it. C.A.R. will offer a free class to do it. So that's starting next year. Here's another law affecting realtors directly. You know, when you put out a sign or you advertise on a website, you have to advertise with your name as it appears on your real estate license. And you also have to put your DRE license number. Okay, your last name. Let's say you have a real estate license, you have a last name, and then you get married or you get divorced, and you change your last name, and you change the name on your real estate license. Here's good news for you. The law now says on your marketing and your signs, you can still use your old last name or your new last name, or both of them. Either one. Take turns. Do whatever you want to do. In other words, if your last name, if you ever had a real estate license with that last name, even if it's not your last name anymore, you can still use that name on all of your marketing, or you can use your new name, or either one. Okay. By the way, what about your first name? Did you know on your marketing you do not have to use the first name as it appears on your license? You can use a nickname, you can use initials, you can shorten your name. You just have to make sure you have the last name as it appears on your current license or a previous license, and you always need your DRE number. Okay. All right. Those are really the only specific laws that affect realtors directly. All right, so we've covered the mold booklet you give to tenants. The Fair Appraisal Act addendum will be attached to the purchase contract July 1st. And there's this new disclosure obligation to your clients if you're aware of a discriminatory restrictive covenant. Then you have more freedom in your marketing, and there's going to be a new class you're going to take. Let's go back and talk about some more forms issued. Might as well, let's get that out of the way. Let's talk about new forms coming out in a couple of weeks, end of June, for the forms release. Other than I already told you about the Fair Appraisal Act. I told you about that. Other brand new forms coming out in 2 weeks. Okay, you ready? One of them is, have you ever had a listing that was part residential and part commercial? or you want to buy a house that's part residential, part commercial. The question is, what purchase contract do I use if I want to purchase a property that's part residential, part commercial? Do I use the residential contract, or do I use the commercial contract, or do I have to use both? You'll be happy to know there's a new form coming out in 2 weeks called the Mixed Use Addendum. Mixed Use Purchase Addendum. This is designed for that. So if you're buying a combined residential or commercial property, you will write the offer on the residential purchase contract, and then you'll attach the mixed use purchase addendum to deal with the commercial part. So you won't have to use 2 different purchase contracts. You use the basic purchase contract plus mixed use addendum. Okay? Brand new form coming out 2 weeks. Speaking of commercial, you know, when you sell a residential house, you have the seller property questionnaire, SPQ. The seller has to answer some questions. 2 weeks from now, there's going to be commercial seller property questionnaire. So if you ever have a commercial listing, you will basically have a nice questionnaire for the seller to answer. And some of the things on this form are actually required. So I would describe this as a mandatory disclosure form. We've never had a nice seller disclosure form for commercial property that covers everything. So now we will. Okay. All right. Couple more brand new forms. Have you ever had a transaction where the client on the other side, they gives you a form that's not a C.A.R. form, right? It's their own form, or it's a different company form, and you figure out, you say, that's not a form I'm familiar with. What am I supposed to do? Well, now we have a new form coming out called Use of Non-Standard Forms Advisory. Use of Non-Standard Forms Advisory. It's a form you would give to your client and say, hey, they're trying to get you to sign a form that is not a C.A.R. form, which means I am not an expert on that form. So I'm advising you that I'll do the best I can, but don't rely on me to be an expert on this form. I am actually advising you, your client, to get separate legal advice to advise them on this non-standard form. Because as a realtor, you're not responsible for being able to understand and interpret non-C.A.R. forms. C.A.R. forms you are required to sort of know. Okay? 2 more new forms. One of them is called Designated Electronic Delivery Address Amendment. By the way, if I didn't say already, a week from today at 1:30, there's going to be a free webinar on C.A.R. going over these forms I'm talking about now. So you don't just have to hear it from me. There's going to be a webinar that's going to have pictures on it, and it's going to be recorded. So 1:30, a week from today, you can find it on the C.A.R. website, webinar on new forms. Anyway, 2 more new forms. So there's a form called the Designated Electronic Delivery Address Amendment. You know, on the new purchase contract, in my opinion, the most significant change on the new purchase contract compared to the old purchase contract is the fact that at the last page of the purchase contract, both of the agents, you know, on the last page of the contract, when the agents fill out their name and their broker's name and their DRE number, and there's broker's DRE number, there's a blank line that says designated electronic delivery address. That wasn't there on the old form. It's now on the new form. What are you supposed to put there? You're supposed to put the email address that you want the other agent to send everything they want to send to you or your client. You're giving them the specific address to send it to. But you know what's significant about that? it says on the contract that if someone sends something to you at the address you gave them, they don't have to prove that you opened the email. As long as they can prove that they sent it, it's considered delivered. Now, for 25 years, I've been telling you guys, when you send an email to the other side, you always have to follow up and make sure they got it. You always have to say, hey, I just sent you an email. Would you please confirm that you received it? Would you please acknowledge that you received it? Because, if you send someone an email, they can always say, well, it's in my inbox, but I never opened it. Or they can say, well, it must be in my spam because I didn't get it. And that's really important, right? Because you're always sending these important emails. You deliver documents. Here's a disclosure. Here's a contingency removal. Here's a notice to perform. But there was always the possibility that the other agent says, I never got it. Well, that's not the possibility anymore. Now, if both agents put their email address on the last page of the contract where it says designated electronic delivery address, you're saying to the other side, if you send it there, you don't have to prove that I got it. By sending it, I got. Well, same thing for me though. If I send you something, as soon as I press send, it's considered received by you. I do not have to prove that you opened it. The fact that I sent it means you got it, which means we all have to check our emails now, right? We can't just say, well, I'm not going to open my emails. It doesn't matter. If it's in your inbox, you got it. If it's in your spam folder, you got it. You can't deny you got it. So keep that in mind. So the point is, what we've noticed is some agents haven't been filling that in. They come to the last page and they forget to do it. What does that mean? Well, that means that we're back to the old way, which is when I send you an email, I have to follow up and prove and get you to acknowledge that you opened it. But we've noticed sometimes agents don't fill that in, but it's just a mistake. They didn't fill it in. They meant to fill it in, but they forgot or whatever. So this new form is simply an amendment where the agent who inadvertently didn't put their email address can now do an amendment with the other agent putting it in. And the reason you would need a form for this is because it's not like a regular addendum between the buyer and the seller. It's got nothing to do with the buyer and seller. It's the agents giving each other a designated address. So you need a form for the agents to do that. And that's the new form that's coming out. Okay. Now I got a couple of questions in chat. Okay. Actually, I have a problem with my computer. Hey, Jeff or Vincent, could you read the questions in chat to me?
Yes, the first question is, what happens if no email written in the area for designated electronic delivery?
Yeah, like I said, if it's nothing there, then we're just like the old contract, which means if I send you an email, you could always say I never got it. So it is significant. Okay.
The second question is, can you provide 2 email addresses on the form?
Sure you can. I mean, if you want to be flexible, you could say, if you email it to either one of these places, that's good enough. Which means, of course, you have to check 2 different places. But sure, it's okay to do that. And by the way, you don't have to put your own email address. You can put your assistant's email address. Any email address you want. You're giving them a designated place that you're always going to check.
And last question, does that presume that the buyer or seller has authorized the agent to receive information on their behalf?
That's a very good question. Under the whole time you've been in real estate, right? You know that you don't deliver things directly to the other client, do you? You deliver it to the agent. Don't you always deliver things to the agent? The purchase contract has always said that. The purchase contract has always said delivery to the agent is the same thing as delivery to the principal. So in other words, yes, your clients have already given you authorization for that. That's been in the contract for 50 years because we don't want you having to track down the other client. It's always better to deliver things to the other agent for them to give to the client. Okay. All right. One more new form. And that is, you know, there's a contract between the broker and the agent. It's called the Independent Contractor Agreement. Do you know for many years we've had two of them? One of them says if you have a dispute, you have to mediate first. The other one has an arbitration clause. So if it's initial, then both sides are agreeing to arbitrate disputes. But I think it was too confusing to have two different independent contractor agreements. So now they're combined into one ICA. And it's going to have both of that. It's going to have mandatory mediation, but it's also going to have, if mediation doesn't work, it's optional, you can agree to arbitration. So two independent contractor agreements combined into one. But there's also an important new change on the independent contractor agreement. You know what the latest lawsuit against realtors has been? Somebody sues you because your website is not accessible to someone who can't see. In other words, a blind person, a visually impaired person can't access your website. I know what you're thinking. How does a visually impaired person access a website? Well, they have software. And if your website has this sign reading software, they can interact and then they can get an audio, you know, all the words on the website, they can get an audio recording of what it says. And it's required that realtors, that your website is accessible to visually impaired people with this type of website reading software. And if you don't have it, they can sue you. So point number one, all of you agents, make sure your website is compliant with the requirements of the Americans with Disabilities Act. Number one, we have on our website, under risk management, we have a bunch of what we call quick guides, like a one-page summary of a law. We have a quick guide on website accessibility. If you get that quick guide, it'll tell you what you need to do. Basically, all you need to do is talk to your website provider and make sure they tell you that your website is in compliance. But you know what this paragraph is set, this new paragraph on the independent contractor agreement says? It says the agent is responsible for your own website. In other words, let's say the agent's website is not in compliance. Your broker's E&O coverage is not going to cover you. If you get sued, you're the one getting sued. They're not going to sue your broker. The broker's not responsible. You've agreed that you're responsible for your own website, which means if there's a problem, it's going to be your problem. Therefore, all agents should take this seriously. And even though that's not on the current independent contractor agreement, we think it's implied anyway, but it's going to be explicit on the new independent contractor agreement. And you know what we've noticed? These lawsuits I've been talking about, they never sue the broker anyway. They sue the agent because it's your website that's not in compliance. And you don't want to get sued. Usually it's like a $5,000, $10,000. You don't want that. So make sure your website is in compliance. Just go to our website under risk management, look for the quick guides, quick guide on website accessibility. It'll tell you what to do. Probably your website is already in compliance. but not all of them are. Okay. All right. That is it for the new forms. What have I told you about today? The mold booklet. That was new January. Then July 1st, we got that Fair Appraisal Act addendum that'll be pre-attached to the purchase contract. We have that disclosure to buyer or owner of discriminatory covenants. We got the mixed use purchase addendum. We have the commercial seller property questionnaire. We have the disclaimer, the use of non-standard forms advisory. We have the designated electronic delivery address amendment where the agent can add their designated email address if they didn't put it in originally. And then we have the combined new independent contractor agreement. So there's only one version of the independent contractor agreement. Okay, those are all the new forms. Well, are there any forms that I already have that are going to be changed in 2 weeks? And just a couple of them I want to mention. One of them is, all right. One other thing we have to talk about is rentals. Because we still have the California eviction moratorium, which is going to last till July 1st. What does that mean? That means you can't evict someone for non-payment of rent unless you use the right form. Remember how there used to be just one 3-day notice to pay or quit, PRQ? Maybe July 1st we'll go back to that. But for now, there are still 3 different 3-day notices. There's one for rent owed to you after this last April 1st. There's one if the rent that you're trying to evict was due before April 1st. And there's a third one if the rent that they owe you that you're trying to evict them for was due prior to last September. So the point is, if you're ever trying to evict someone for non-payment of rent, you have to make sure you're using the right form. So if you're ever trying to do that, call C.A.R. or call a lawyer first to make sure you're using the right form. Okay? Now, then there's this federal law, which says if you're trying to evict a tenant and the property is securing a federally related loan, so the landlord's property is secured by an FHA loan or a VA loan or a conforming loan that was sold to Fannie or Freddie, or if the tenant is receiving any type of subsidy like Section 8, and they're not paying rent, you got to give them a 30-day rather than a 3-day pay or quit. You know what's funny? The courts don't seem to be following this. So we are hearing evictions are happening on these types of properties with just a 3-day notice. Some of the California courts don't even seem to be aware of this federal law that requires you to give 30 days rather than 3. So what we've done is we've created this form that's attached to the 3-day notices that just tells the landlord, you know, we need to tell you this. There is this federal law. We don't know if the courts are going to enforce or not, so we're just telling you. I guess the worst thing that can happen is you give someone a 3-day notice to pay or quit, and then the tenant responds says, oh no, my property is securing a federally related loan. You should have given me 30 days rather than 3, in which case you'd have to start all over. The point is, we don't want to put that right on the 3-day notice form because it's a federal law, it's not a state law, and most of the state courts don't seem to be following it. but we do want to educate landlords that there is this law out there. So there's this sort of attachment to the 3-day notices forms, which is for the landlord to read, but then they would tear it off and don't actually give it to the tenant. The tenant, you're just going to give them a 3-day notice and hope they don't bring up this federal law as a defense. Or you can be real conservative and give them a 30-day pay rent or quit. That's up to the landlord. Bottom line, if you are a landlord or you are a property manager, you might want to call the hotline before you try to evict somebody. What if you're not the landlord, but your client is a landlord and they start asking you, hey, I want to evict this tenant. What do I do? You know what the answer is. You need legal advice. This stuff is complicated. And then they're going to say, yeah, but you're my realtor. You should be able to help me. And you're going to say, yeah, but I'm not your eviction attorney. But if you want to, you can still call the legal hotline. We'll tell you what to do. But ideally, you're not the one advising your client on evictions. But you may be a landlord yourself, or you might be a property manager yourself, in which case you definitely do have to know the thing to do. So call the hotline or have your client get an attorney, because evictions are still not back to normal. Maybe they'll be back to normal soon. July 1st, maybe. But for now, evictions are still not normal as far as the forms you have to use. By the way, the good news is you don't have to apply for rental assistance. Remember, up until April 1st, before you were going to evict someone, the landlord first had to apply LA County rental assistance. You don't have to do that anymore. But if you already did apply for rental assistance and the city hasn't gotten back, the county hasn't gotten back to you, yes or no, you have to wait until July. You can't evict until July 1st until you get the answer. What if July 1st comes along? I applied for rental assistance. I still haven't heard yes or no. Well, starting on July 1st, you can just evict. You don't have to wait anymore. But if you've applied for rental assistance, they took your application, but they haven't answered you yet, you can't evict until July 1st if you don't get an answer. Now, if they give you an answer, here's the money, obviously you can't evict, you got the money. Or if they give you an answer, we don't have any money for you, of course, as soon as they tell you that, you can evict. But if you're just waiting for an answer, you got to wait till July 1st. But for new evictions, for tenants who owe you rent after April 1st, you don't have to apply at all. You can just evict. You just have to use the right form. Isn't it crazy? You can't wait right till evictions are back to normal. Maybe July 1st, if it doesn't get extended again. You know what the problem is? On July 1st, when the California eviction moratorium ends, local governments can reimpose their own eviction moratoriums. I guarantee you, if LA City, not county, LA City, on July 1st, is going to impose their own new eviction moratorium. So if I were an LA City landlord, I'm going to evict them before July 1st. I'm going to get the process started, because July 1st, you're not going to worry about the California one. You're going to worry about the LA City. They're going to have a new eviction moratorium for COVID people. What about County of LA? So you're in County of LA, you're not in City of LA. Well, you're good. I mean, hopefully you'll be able to go back to normal. You won't have to worry about what form to use. Hopefully on July 1st, you'll be able to evict with a normal form. We don't know yet though, because the California eviction moratorium that is scheduled to end July 1st, there's always the possibility it gets extended again. That would actually be good news for California, for LA City landlords, because the LA City ordinance that is going to go into effect when the California eviction moratorium ends is going to be stricter. But you guys, I think, are mainly LA County, not LA City. So you want the California eviction moratorium to end so you can go back to normal. But since I'm talking to LA County people, of course, I do need to remind you, unfortunately, that you still have the problem in LA County that you can't do no fault evictions unless the owner wants to move in. I mean, if you were anywhere but LA County, if you were in Orange County and you had a listing on a house and the tenant's month to month, you could just evict the tenant because you want to sell it. LA County, no. You can't evict a tenant just because you want to sell the house. The only person that can evict the tenant, assuming the tenant's not doing anything wrong, is the owner. So you got to sell the house to the buyer, and then they can evict the tenant if they want to move in. I always say, you go to the tenant and say, listen, I'm going to sell this house. When I sell it, the buyer's going to kick you out. How about you move out early and I'll give you a 3 months rent or something like that. So you give them some incentive to leave. But in LA County, the tenant does not have to leave just because you want to sell the house. Assuming the tenant is not doing anything wrong, the only person that can evict them is the owner who wants to move in or a family member move in. And then it gets complicated, relocation. Once again, if you have clients asking you questions about this, either make them get a lawyer or call the legal hotline so we can make sure you understand the rules, okay? You know how bad it is in LA County right now? You can't even evict a tenant for having illegal subtenants. You can't even evict a tenant for having illegal pets. LA County is not good for landlords right now. And LA City is even worse. So hopefully these things will change soon, but for now, it's complicated. Let me just, since I'm talking about rentals, let me finish up by talking about the question that people keep asking. Hey, with all this inflation, I want to increase my tenant's rent. How much can I increase the rent? And when someone asks me that, I say, I'm going to ask you 3 questions. Question number 1. Are you in a city with rent control? Are you in LA City? Are you in Santa Monica? Are you in West Hollywood? Are you in Culver City? Are you in a city with rent control? And they say yes. Then I'm going to say, well, depending on what city you're in, if your property comes under that city's rent control, that's going to control how much rent you can increase. And did you know if your if your rental property is under LA City rent control right now, there's a rent freeze. You can't increase their rent at all. What about Santa Monica, West Hollywood? Well, you can do a slight increase, but not much. But let's say you're not under a city rent control, or you're in a city, but you're not under rent control. Then I'm going to ask you, okay, if you're not under city rent control, is your property more than 2 units? And is it older than 15 years? If you say yes, I'm going to say you're under California rent control. And then you're going to say, well, how much can I increase the rent? And I'm going to say, since you're under California rent control, you can increase it by 8.6% until August 1st. After August 1st, you can increase it by 10%. So if you're in LA County and you're under California rent control, the maximum rental increase is 8.6 today. If you wait till August, it's a maximum of 10%. But what if I have a single family home or a duplex? So I'm not under rent control. Or what if I have a building that's newer than 15 years? So I'm not under rent control. how much can I increase the rent? Can I increase the rent as much as I want? Can I increase it by 100%? And the answer is normally I would say yes. But if you're in LA County is under a county-wide state of emergency. And anytime your property's in a county with a state of emergency, the anti-rent gouging laws limit you to a rent increase of 10%. Bottom line, nobody in LA County can increase the rent by more than 10%. And some people can't even do it that much. If you have a specific property, call the hotline, call your lawyer. We'll figure it out how much you can charge. But I'll tell you right now, it's never going to be more than 10. Now, this California state of emergency hopefully will be over soon. At that point, you'd be able to increase your rent on a single family home as much as you want. You can 5 times as high as it is now, whatever you want. But for now, can't do it. What if I'm in Orange County? Single family home, Orange County, I have to check, but I think you pretty much can do what you want in most places of Orange County. Okay? All right. Isn't renting a nightmare right now? It really is if you're a landlord. It's going to get better, but for now, we got to deal with it. Okay? Enough on rentals. Are there any other forms that are changing in a couple of weeks that I need to know about? Okay, so I told you about there's a new form for the evictions, and you still got to use those forms. Are there other forms that are changing that I need to know about? Couple things, nothing too significant. One of them is, have you ever had a deal where you want to cancel the contract, but there's no deposit? In other words, obviously, when you cancel a contract where there's already a deposit in escrow, you have to resolve who gets the deposit. But what if there is no deposit? What if you're canceling the deal before they even put a deposit in escrow? Well, now on the cancellation form, the CC, there's a checkbox where you check, well, there is no deposit. And then what it says is, if there's no deposit, you still have to pay the escrow company the fees that they've already incurred. You got to pay the cancellation fee. And if either the buyer or seller has already promised to give the other side money and the deadline is already passed for that, you still got to pay them. In other words, just because there's no deposit doesn't mean that the buyer might still have to come up with some money, or the seller might have to come up with some money to pay the escrow company or something like that. So the cancellation form now addresses the issue of canceling a contract even before you even got a deposit. I know some people think, I thought there's no contract if there's no deposit. No, there's no escrow if there's no deposit. But as soon as the buyer and seller sign the contract and deliver it to each other, there is a contract, and there might be money you have to pay. Which leads to another question. Have you ever had a buyer cancel the deal before they put the deposit in? They figure they're good. Well, there's no escrow, but there's still a contract. And if there's no deposit, there's no liquidated damages. But the seller can sue the buyer for actual damages. I mean, some buyers think, well, as long as I never put money in there, nobody can sue me. Not true. When you sign the contract and the seller accepted it, you have a contract. If you breach that contract, you could have a problem. Now, of course, if they haven't removed their contingencies, or if they haven't got the disclosures, they can always get out of the deal. But I don't know about you guys, but I see offers that have no contingencies. And I see offers where they've already received the disclosures, so they really don't have the right to cancel. In those circumstances, the seller could sue them even though there's no deposit in escrow, okay? That doesn't happen that much, but it does happen. All right, okay. The listing contract. All right, the listing contract that you all use. Did you know there's a paragraph right now that says if the seller and the listing broker get involved in a lawsuit over the commission, whoever wins the lawsuit, the loser has to pay the winner's attorney fees. That is gone. In the new version of the listing form coming out in a couple weeks, there's no attorney. In other words, in any lawsuit, you each pays their own attorney. Okay, so no more is there going to be a clause that says in a commission dispute, the loser has to pay the winner's attorney fees. Okay, so that's a change. Another change is, in the purchase contract, there's no more representative capacity signature disclosure form. So if the buyer or the seller is a trust or a corporation or an LLC, you don't need that addendum. You just simply call that person the legally authorized signer. And on the signature page, they just check the box, I'm a legally authorized signer, and they put down who they are. You don't need that representative capacity signature disclosure addendum anymore. Well, starting in 2 weeks, that's going to be the same thing on the listing form. So let's say you take a listing from a trust or a corporation or something, you're not going to need the RCSD in that situation either. You're only going to need it. You're not going to need it at all. Just like you don't need it on the purchase contract anymore, you're not going to need it on the listing contract anymore. Okay? All right. So those are the changes to the listing contract. Are there any other forms that are going to change I need to know about? Well, the statewide buyer and seller advisory, it's going to have a new bigger paragraph talking about the issues about sea level rise. So if any of you guys have a listing on the coast, there's going to be more information to your clients about all the legal ramifications of potential sea level rise. That's not a big deal. Okay. One other thing. We have this form called the request for repair. So I'm the buyer, you're the seller, right? And I get an inspection, and my inspector finds some problems, and I want you to fix them. So I give you a request for repair. Hey, seller, I want you to fix XYZ. And the seller says, I'll fix it. I'll promise to fix it, but I'm not going to start doing that work until you remove your inspection contingency. I mean, until you remove that, I'm not doing the work. So I'm not agreeing to do the work unless you agree to remove your inspection contingency. Well, some sellers have been saying, I'm not going to do that work until you remove all your contingencies. So now there's going to be a place on the request for repair form where the buyer says to the seller, I'm removing all of my contingencies. Because you know how it is. The seller says, you're asking me to spend a lot of money to do this stuff, and you may still back out of the deal. I want you to be committed. I don't want you to just remove this contingency. I want you to remove all your contingencies. Buyer may say no. You may have you keep negotiating and see what you can do. But the point is, there's going to be a place now on the RR form for the buyer to check a box, attach the contingency removal form, and then remove all their contingencies in exchange for the seller agreeing to do the repairs that the buyer requested. Remember, the seller never has to do those repairs, but now they can put a sort of a condition on doing it. All right. That is all you need to know about forms, with one exception. I saved one for last. And that's the most complicated form you deal with now, which is the fire hardening defensible space. That form is going to be tweaked a little. but it's still going to be in essence the same. The good news is for you guys is most of the guys I'm talking about on this call, the ladies and gentlemen I'm talking to, you usually don't live, your listings are usually not in fire zones because you're in pretty much urban areas. There are still fire zones in LA County though. The point is this, right? Every time you take a listing, you have to determine if your listing is in a very high or high fire hazard zone. And of course, you rely on your trusty NHD company to help you figure that out. John Wax is waving to the camera, yes. So once you've figured out you are in a high or very high fire hazard zone, you know you need this form. Then the form gets confusing because there's two parts to it. There's the home hardening part, and then there's the defensible space part. And then there's another confusing part that says the seller can check a box and say, I'm giving you this form even though I don't have to. Some sellers, for some reason, want to give them the form even though the property's not in a high or very high fire zone. Well, guess what? That paragraph is gone. So when the new forms come out in 2 weeks, the fire hardening defensible space form is no longer going to have an option for the seller to say to the buyer, I'm giving you this form even though I don't have to, because that just caused too much confusion. I think it makes sense. I'm going to give you this form if I have to. If I don't have to give it to you, I'm not going to give it to you. I'm going to give it to you if the property's in a high or very high fire zone. If not, I'm not going to give it to you. So that's one change. Another change, there was a paragraph in there just with general advisory information about fires. That information was not required by law. So the forms committee said, let's just, if it's not required, we'll take it out. We'll put that information on the wildfire advisory, but we're not going to make it part of this required fire hardening defensible space form. And the third thing, on the current form, in paragraph 3, there's 6 questions for the seller. Are you aware, do you have a wood roof? Do you have single pane windows? Do you have rain gutters that don't have metal facing or whatever? And there's a checkbox, yes. And the seller says to you, I don't know, I don't have a wood roof. And you say, then don't check yes. But they say, aren't I supposed to check no? Well, in the old form, there's no place to set. It's either yes or nothing. But you know how people are. They like to check a yes or a no. So on the new form, when you get those 6 questions for the seller, do you have wood roof? Do you have single pane windows? There's a yes and a no. So they can always check one of the two. And I think people are happy with that. They don't like yes or nothing. They want to specifically say yes or no. All right. So that's a change. So these aren't big changes, but they're nice changes. No more optional, give you the form even though I don't have to. No more superfluous language about it, advice, and no more. And now you say yes or no. And then remember, when it comes to defensible space, LA County, I guarantee you, there's nowhere in LA County where it's mandatory that you have to do a defensible space inspection before close. Therefore, when you're filling out that form as a listing agent and you come to the defensible space paragraph, you only have to ask your seller one question. Hey, seller, in the last 6 months, did you get a defensible space inspection? Now, if the seller's in Big Bear, the answer is they'll probably say yes. But if the seller's anywhere else in LA County, they're probably going to say no. They're not even going to know what you're talking about. What do you mean a defensible space inspection? So they're going to say, no, I don't. I never got one in the last 6 months. If that's the answer the seller gives you, you're not going to check any of the boxes under defensible space. You're just going to, it's going to default to the first option, which says buyer within a year after close will take responsibility to obtain documentation that they're in compliance with the defensible space law. Remember what the defensible space law is? It says if your house is in a very high or high fire zone, you have to have 100 feet of defensible space. Now, where you guys are, maybe there, I don't even know if there are any very high or high fire zones in West San Gabriel Valley. I don't even know. There probably aren't very many if there are any. So none of this may ever matter to you. You may never even use this form. But if you take a listing in the Valley, you take a listing in Malibu, there are places in LA County where you definitely need this form. Okay? All right. We are done with forms. We're done with evictions. You can use your name. You're going to have a new class. What else do I need to know about? Just a couple things. First of all, make sure your clients understand about Proposition 19. If your client is over 55 or severely disabled, or they have a house that was damaged in any way in a wildfire, they can take their property tax on their current house and move it to their new house. In other words, they bought a house 30 years ago for $150,000. It is now worth $800,000. They're paying property tax based on 150. It's now worth 800. They can sell it for 800, buy another one for 800. In fact, they can buy another one for up to 880 if they wait a year before buying it, and their property tax will not go up at all. They can transfer the low property tax based on the 150 that they paid 30 years ago to the new house. Well, what if I bought it for 150, it's worth 800, and I buy a new one for $1 million? So it's above the 880. It's more than 10% more than the sale price of the old one. You can still take advantage of this. See, under the old law, if the new house costs more than 10% the value of the old house, you couldn't transfer your property tax at all. Now, even if the new house is more than 10% more than the old house, you still get a break. Here's the numbers. You bought the old house 30 years ago for 150. It's worth 800. You sell it for 800, you buy a new one for $1 million. What is your property tax basis going to be on the new $1 million house? It's going to be the original 150 plus the difference between the sale price of the new one, purchase price of the new one $1 million, and the sale price of the old one 800. That's 200. So you add 200 to the 150. Your property tax basis on the new house is going to be 350, which is a lot better than $1 million. Couple of things to tell you. Both of the, if the property is owned by a married couple, only one of them has to be 55. You can buy the replacement before you sell the original. You can sell the original before you buy the replacement. You got 2 years to do it. And when you do the first part, you don't have to be 55. You could be 53 or 54. It's only when you do the second half, you have to be 55. Okay? What if you have a married couple over 55, they're getting divorced. They want to sell the family house and they each want to buy a new house. Can they each transfer the low property tax basis on the old house to their new house? No. Can they each take half? No. One of the two can transfer the old one, the other one can't at all. Well, which one can do it and which one can't do it? The one with the better lawyer gets it. No, just kidding. They're going to factor this into the divorce proceedings. In other words, okay, you get to transfer the property tax, so you get something else. But it's one of the two is going to get it, okay? What about the opposite situation? You got two people, both over 55. They each own a house. They want to get married and buy a house together. Which one of them can transfer the property tax on their existing house to the new married house? And the answer is whichever one sells first. Okay, so you're going to figure that out, which is the best advantage to do that. Okay, so that's the latest on Prop 19. Make sure your clients are aware of this. What else is going on? Well, we got this law called SB 9. I just want to make sure everyone sort of understands this law. Okay, so I got a single family. California has something called zoning. And whatever your property is zoned for, that tells you what type of building you can build. So let's say I'm in R1 zoning. That's single family zoning. Traditionally, that means you can have one house there. Single family zoning, one unit. What if I wanted to build a second house on my single family house? You'd have to apply for a zoning variance. You probably wouldn't get it. Then we got this new law called SB 9. You own a house in a single family. You might be able to build another house and have two houses on the same lot. Well, who can do that? Well, first of all, you can't do it unless you're in an urban area, but you guys are in an urban area. But you also can't do it if the property you're talking about is in an earthquake fault zone, very high fire zone, 100-year flood zone, landmark area, historic area, conservation area, protected habitat. But let's say my house is not in any of those things. Can I build a second house on my lot? Answer, yes, you can do it. What if I have an HOA? My house is part of an HOA and the CC&Rs say I can't do it. Then you can't do it. CC&Rs take precedence over this law. Okay, I got a single family house, no CC&Rs, no HOA, no earthquake district, no flood district, no fire zone. Now can I do it? Yes. Well, can I build another house as big as I want? No. The city or county the city you're building in can still restrict you. It's got to have it's got to look a certain way, and they can actually restrict the size to no bigger than 800 square feet. So it's not like I can just build whatever I want. I mean, maybe the city you're in is okay with that. Some cities are saying build as big as you want. But the city would have the right to say, you want to build a second house? Okay, can't be bigger than 800 square feet. So to me, SB 9 isn't as big of a deal as it could be because you do have that limitation. But here's the thing that that a lot of people don't know. Even before SB 9, if I own a house on a single family lot, I can build an accessory dwelling unit. I can build an ADU up to 800 square feet. And the HOA can't even stop me. Nobody can stop me. So if you think about it, property owners didn't really even need SB 9. You can always build an ADU. And the HOA can't even stop. Once again, it's got that 800 square foot limit. But you can do that even without the HOA's approval. I guess the only advantage of building a SB 9 unit is theoretically you could sell it separately, but it's pretty hard to sell it without the lot. Which is why there's one other thing to tell you. I think you know this. If I do own a single family property that's at least 2,400 square foot lot, I can do a lot split. As long as, I'm not an earthquake zone or any of that stuff. And as long as I commit in writing on an affidavit that I'm going to live in one of the units for at least 3 years, you could actually take my single family lot, do a lot split and build 2 units on each lot. So I could turn a single family into 4 units. Once again, got to be urban, no earthquake, no flood, no fire, no CC&Rs. But assuming none of that is in your way, and each unit, they can limit you to each, none of the units can be bigger than 800 square feet. But assuming that's what you want to do, you can do it. So it's a little bit complicated. And you can always build an ADU. That's not a lot split, but you can always build an ADU even before this law came out, as long as the ADU is no more than 16 feet high, 4-foot setback, and no bigger than 800 square feet. And the HOA cannot stop an ADU, okay? What if I want to convert my garage into 1 unit and also build a detached ADU? You can do both if you have a single family home, okay? All right, the very last thing I want to mention is, I always save this for the last because I always get questions on this, is emotional support animals. Did you know there are 2 different things? There's service dogs and emotional support animals. You notice I didn't say service animal, I said service dog. Service, there's only 2 types of service animals, a dog or a miniature horse. I'm going to assume we're not talking about a miniature horse. So if you have a service dog, what that means is you're disabled and you have a dog that has been specifically trained to do something that you can't do because of your disability, like a seeing eye dog. If you have a legit service dog, you can take that dog anywhere. Airplane, train, boat, ship, museum, restaurant, everywhere has to allow a service dog. But if you have an emotional support animal, they don't have to let you on the plane. They don't have to let you in the restaurant. They don't have to let you in the museum. They don't have to let you go anywhere, except in real estate. Landlords have to allow emotional support animals. HOAs have to allow emotional support animals. So the question is, you're a landlord or you're an HOA, you have a no pet policy. And somebody shows up with an animal. And you say, I'm sorry, no pets. And they say it's not a pet. What is it? Well, if they say it's a service dog, that means, you know, they are disabled and the dog has been trained. You're entitled to ask them that. What's your disability? You know, are you disabled and what's the dog trained to do? But what if they say, no, I have an emotional support animal? What proof are you entitled to? Well, here's the change. Last year, this person, all they had to do was go on the internet and look for emotional support animal certification, and they could email some stranger on the internet and say, hey, I think I need an emotional support animal. And the person on the internet said, yeah, I agree with you. Here's your certification. It was that easy. The good news, I mean, nothing against emotional support animals, but I don't know about you, but I've run into people who really are they just want a pet. It's not an emotional support animal. Anyway, the point is now, the only people that can provide this certification is a caregiver that has been actually physically taking care of this person for at least 30 days and has done a clinical examination of this person and has determined that they need an emotional support animal. So they can't just go to some random person on the internet anymore. The point is, it's harder to get a certification. It's still not that hard though, because the caregiver unfortunately doesn't have to, in my opinion, unfortunately doesn't have to be an MD. Could be just like a therapist or something like that. So anyone who's been taking care of this person. Okay. All right. I forgot to say there's one more thing I want to talk about, and that is Section 8 and the DRE. The DRE has said two important things you all need to know. Number one, they don't like agents doing open houses for other agents in different offices. The DRE says when you're sitting in an open house, that is licensed activity. If you so much as open your mouth, it's licensed activity. You can only do licensed activity for your own broker. So if your friend at another office has a listing and they want you to sit at that listing, open house, that means you're working for their broker and you can't do that. Yeah, theoretically, you could just go there, smile, hand out flyers, but that's not why you're doing an open house. You're doing an open house to talk to people and get clients. The DRE says they're going to start cracking down on this. They don't want you to do. Okay. The second thing the DRE said is to reinforce what the California Department of Fair Housing says is landlords cannot refuse to rent to Section 8 tenants. There are a lot of landlords who haven't got this message and they're getting in trouble. Some landlords are so out of it, they're still putting ads out. We don't take Section 8. In other words, I'm admitting I'm committing a crime. So you can't do that. If you're a landlord and a tenant calls you, someone calls you up, you take Section 8 tenants, you say, absolutely, we take Section 8 tenants. I mean, that doesn't mean you have to take every tenant that walks through the door. You can still screen them. You can still check credit scores. You can still have a standard that says, I don't rent to anybody with a credit score under 700 or whatever. And then you don't have to rent to someone. But if you get a Section 8 applicant whose credit score is over 700, you better take them. Unless you have some other objective criteria that they are not meeting. And they're really going to start cracking down on this because it's pretty rampant that people haven't got the news that landlords cannot refuse to rent to Section 8 tenants just because they're Section 8. Okay? So, one more thing, as I mentioned when we talked about the form, the DRE is also saying when it comes to the website of the agent being in violation of the Americans with Disabilities Act, that's not the broker's responsibility. So the DRE is not going to punish the broker because the agent's website, their personal website, is not in compliance. And one more thing the DRE said is, if your client asks you to recommend a licensed contractor, you don't have to do that. But if you do, you, the realtor, need to check the Contractor State Licensing Board website to see if that licensed contractor still has their license. So it's very easy to do that. Contractor State Licensing Board website, you look under license check, you can do it. But the point is, you could get in trouble if you recommend someone thinking they're a licensed contractor, but it turns out that they're not. Okay? And the other thing is, you also have to check and see if the licensed contractor has workers' comp. Now, if the contractor is a sole person, of course they don't have workers' comp. But if the contractor you're recommending has employees, realtor needs to check, make sure they have workers' comp. And that is also on the CSLB, Contractor State Licensing Board website under license check. All right, ladies and gentlemen, I've told you a lot of stuff. You may not remember it all, but maybe you took notes. You can look at it again. And remember all the form stuff I was talking about. There's going to be a free webinar with pictures of the forms, 1:30 a week from today. And if you can't make it, it's going to be recorded. It'll be on our website forever. You can always go back and look at it. Okay? Any questions that I haven't already covered? This is now your time if you want to. You can either, yeah.
We have some questions. So back to the rent increase, if it's just under the state rent restriction, start from August, we can have 10%. But the question is, can we send out the 30 days notice in June or January?
Yeah, sure. In other words, as long as it's not effective until August 1st.
Okay. Then the next question is the housing Riverside. The agent is asking, can you evict the tenant if you're trying to sell the property, but the tenant is not allowed the showing?
That's a very good question. Yes. If the tenant is not allowing showings, that is grounds for eviction, because that's not a no fault eviction. Now, did you say where was this you're talking about?
Riverside.
Yeah, Riverside, you can evict for any, you don't even need a reason. So Riverside County, yes. What about LA County? Can you evict in LA County if they won't allow showings? Yes. What about LA City? No. But Riverside, do whatever you want. There are no restrictions on evictions like that.
Okay. We have next question from Mary Scott. Is the federal 30-day notice a notice to pay or quit, or is it a termination notice?
Crazy thing is, it's a 30-day notice to quit. In other words, you could give them a 3-day notice to pay, but they don't have to leave for 30 days. The crazy thing is, the California judges don't seem to be following this. They seem to be allowing just a regular 3-day if you use the right form. But as your lawyers, we do have to tell you that there is this federal law out there that hasn't been repealed yet. So it's crazy, but yeah, there you go.
Okay, the next question is, the property owner hired a vendor, but the vendor provided the false social security number, and the property owner find this out during the tax filing. What's the remedy?
Well, the remedy against who? I mean, in other words, they don't want to pay the vendor, or maybe whoever asked the question, what is it that you want to do or not do? I mean, if, yeah.
Yeah, because this is just this, let's just skip this question.
Okay.
Then the next one is about the rent increase for the unincorporated area of Los Angeles County.
Yeah. Once again, we're talking about, there's no rent freeze in LA County, so you can increase it. I haven't even looked recently. You know, I apologize. You have to call me or call the hotline. I'm not sure what it is, LA County. In unincorporated, there may not be any restriction, but remember, the entire county is in a state of emergency. So everywhere in California, in LA, even single family homes, incorporated, unincorporated, LA City, LA, everywhere, there's a max of 10%. Now, if at LA City, it's less than that. If your other cities, it's less than that. Unincorporated LA County, I'd have to check. I'm sorry. Call me, call the hotline. Be glad to give you that number. But it's never going to be more than 10 right now. And if we're talking, and remember, if you're, in other words, pretty much if unincorporated LA, it's probably going to be 10, right? Because if it's more than 2 units and over 15, you know it's going to be 10 maximum August 1st. But even if it's single family or a duplex, state of emergency 10%. So it's never going to be more than 10%, but I'd have to check. I don't think so, but let me check if LA County has any other restriction in unincorporated. I just don't know. I don't remember.
Okay.
But
and,
yeah.
I'm sorry. So
Keep
the
going.
next one, the duplex in LA County is not in LA City, also not under rent control.
Right. but we still have this 10% state of emergency limit. So it's still 10%.
Still 10%. Okay.
Yeah.
Then the next question is from Earl, that if the seller sends a counter offer to buyer without one seller's signature, and then buyer signs it, but then the seller then signed a new offer higher, does the buyer have recourse against seller or against due agent?
I'm going to answer this sort of as a general thing, because if it's specific, you need to call the hotline. In general terms, though, everybody's got to sign. So if there's a situation where either on the buyer's side or the seller's side, not all the principals signed, there's no binding contract. So the buyer couldn't force the sale. Say, buyer, you didn't get everybody to sign. And that's, you can't say, well, that's their fault. Well, it's your fault. You need to push it to get them to sign. If they didn't sign it, there's no deal.
Okay, so next question is from Mindy. Am I able to submit an amendment if I just signed a listing agreement a week ago? May I submit an addendum in regards to what you just mentioned, to the winner party pays the attorney fees between seller and the listing?
So in other words, you signed a listing on the old form, the current form. And now, since I just told you the new form is going to change, you say, I like that thing on the new form. Can we do an amendment to the existing listing to say attorney fees, the loser doesn't pay? Yeah, if the seller will agree to it, absolutely. Just like any other amendment. If they don't agree to it, though, you're stuck with what you have.
So next question from Earl. What if listing agent does not tell seller about Proposition 19?
That's a good question. It is not, you're not a lawyer. It is not your legal obligation to tell your clients. I'm saying it's probably in your interest to get business, to tell people, hey, maybe the reason you're not listing is because you're worried about your property tax going up. I got good news for you, but no, it is not your obligation as the realtor to tell them about it.
Okay. Next question is from Ling Chao, is regarding the rent subsidies. Said, what about tenants stated that they have some types of 6 months free rent from some type of agency? Does the landlord have to accept?
Great question. Yes, it's just like Section 8. In other words, you can't reject a tenant just because they have some type of subsidy, some type of free rent. I mean, you make sure you're rejecting them for something else. In other words, their credit score, their criminal record, whatever. But you can't just reject them simply because they've got any type of subsidy.
Okay, the next question from Joanna Ling. What about when refer handyman, any requirement?
No, there's no, I mean, obviously a handyman is a non-licensed person. There's really nothing you can check, right? So no, there's no particular, you don't have to check anything.
Okay. Then next question from Jeff. For the California state rent control, does it apply to roommates within a single family home under month-to-month, no lease contract?
Very good question. And the answer is yes, you still can't increase rent by, I mean, roommates, by the way, all the fair housing laws don't apply to roommates. You can discriminate all you want, but there are restrictions on how much you can charge them. Okay.
Okay, next question is from Anita. Do you know if there is any sale eviction restriction for Rancho Cucamonga and Montclair in San Bernardino County?
Off the top of my head, no, there are no restrictions. I'm pretty sure there aren't any.
Well, next question is from Cecilia. I thought we couldn't check criminal record anymore or reject them for it.
You are a very smart person. So I'll give you the specific rules. You are exactly right. Here's the rule. You can't check criminal until you've checked everything else first. In other words, and I should have said that before. So in other words, I get an applicant. I can check their credit, income, blah, blah, blah. And then I say, okay, you are good. I take you. Then and only then can you check criminal. You can't check criminal until you've actually approved them based on everything else. Then when you do check criminal, what if they have a criminal record? Can you automatically say no? No. Felony, yes. Violent crime, yes. Fraud, yes. But what if their criminal record is just drunk driving 20 years ago? Or they got drunk in a bar, created a disturbance, whatever. Then you probably cannot. In other words, it's got to be, it's not a black and white rule, but it's got to be more or less serious crime or repeated crime or recent crime. If you're unclear, call an attorney, call the hotline. But I'm glad you asked that. Yes, you can't check criminal until you're at the end. But then if you do check and they have a violent background, yes, then you can of course reject.
Okay, so the next question is from M. This is a very detailed eviction question. Does San Bernardino County allow for eviction? Tenant didn't pay the rent for
let me stop you, Vincent, right there. If it's going to be a complicated, specific question, maybe send me an email.
Okay.
My email address is govh@car.org, govh@CAR.org, or call the hotline. But yeah, let's not get into very specific, detailed questions.
Okay. Then the next question is for selling and eviction. Is there anything the owner can do to ask the tenant to vacate? The agent is selling a duplex in LA City. Then the new buyer wants to live in the duplex with the family.
Yeah, like I said, you can't evict them. The owner can kick them out, but you can't force them out until that happens. You can talk to them, you can say, listen, if you leave early, I'll give you something, you know what I mean? But if they're smart, the tenant knows they're entitled to relocation anyway. A lot of relocation. The new owner is going to have to give them a lot of relocation. So you don't have too much to bargain with when you're in that situation. Yeah, so.
Okay, we have a last question. Irvine, Orange County, any restriction for increased rent for single family and the townhouse?
Yeah, just like when you asked about Rancho Cucamonga, Montclair, I'm going to say no. I just can't 100% guarantee it. You might want to call the hotline to 100% guarantee it. As far as I know, there's nowhere in Orange County that has rent control. Remember, though, you always have to think about California rent control. And even if you're not under California rent control, you have to think about state of emergency. So Orange County, single family house, there may not be any restriction at all. Email me or call the hotline. I'll confirm that. Okay. Yeah, your specific eviction questions, some of them, the LA ones I'm definite on, but the other ones I'm not definitely sure all the time. So anything I said I wasn't 100% sure, you need to email me or call the hotline and we'll give you a definite answer. And I'll give you the hotline in case you don't know. 213-739-8282. 213-739-8282. My email, govh@CAR.org. You want to know my cell phone? I'm not going to give you my cell phone. So.
Okay, great. I think that's all the question we have of today. It's very detailed explanation for the legal update. Thank you very much. I saw lots of people type thank you in the chat box. Thank you.
My pleasure.
We have a
See you
floor
guys next
back
time.
to Jeff. Thank you.
Thank you, Vincent. On behalf of West San Gabriel Valley Realtors, we'd like to thank Gov Hutchinson for being our guest speaker and for your informative presentation today. We have an amazing lineup of useful, interesting classes upcoming. On June 14th, our commercial seminar, 10 Mistakes Broker and Investors Make with income property investment. June 15th, we have understanding ADUs, how to assess and visualize what is possible on any California property. And on June 21st, it's our lunch and learn, rev it up with your listings in reverse mortgage. We hope to see you then. Till then, goodbye.